Hi everybody, I'm Maricopa County Attorney Rachel Mitchell. Last time we addressed bonds or bail. This time we're going to talk about how do prosecutors make charging decisions. So let me walk you through the process. When somebody is booked into jail for a crime, they have to receive their initial appearance in 24 hours. That means that they have to go before a judge, and that judge has to set bail or bond or other release conditions. Our attorneys staff that jail court 24 hours a day, 7 days a week, so that we can make recommendations on the bail. Once that person receives their initial appearance, or IA, we then have 48 hours to file charges in order to maintain those conditions, the bond amount or the other release conditions. So what do we do in that 48 hours? Well, we receive a submittal from the police department that is recommending charges, and we have to review that. And the standard that we use for charging in the Maricopa County Attorney's Office, as do many prosecution agencies across the country, is there a reasonable likelihood of conviction? What does that mean? That means that I, as an experienced prosecutor, am going to look at the case and determine whether, if this goes in front of a jury, whether I can be successful in court. So our juries are either 8 persons or 12 persons, depending on how much time the person is facing. And so I'm looking at it to see whether I can present it to a jury and have them come back unanimous in favor of a finding of guilt. That takes a lot of experience to judge that, a lot of time in the courtroom to determine whether I'm going to be successful. So sometimes on very complex cases, what we'll do is we'll have a group of attorneys, senior staff attorneys, review the case to determine whether there is a reasonable likelihood of conviction. You've probably heard that just recently we charged 7 individuals in the homicide of a young man that occurred in the Southeast Valley. And that was the standard that we used in that case, as we use in every other case, to determine whether to file charges. If we don't think that there is enough there, one of the options that we have is to further the case back to the police agency and ask for additional information or additional investigation. We also have the ability to say, we are not going to file this case. Maybe it doesn't meet the statutory definition of the crime. Maybe there's inadequate evidence. And in that case, we will turn the case down. We also are limited to reviewing the facts of the case in front of us. We can't just look at somebody's criminal history and say, well, that person has a criminal history, so they must have committed this crime. We are limited to the facts and evidence in the particular case in front of us. So that's how we make charging decisions. Please keep your questions coming in as to parts that you would like to learn about in the criminal justice system, and we'll try to get to those. We'll answer one each month. Thank you very much.